49 questions, which is amazing. 40 questions now. So let's get started on them right away. So we have the first one from a board member. If the board requests from the management company, like an explanation or discrepancy in the financials, how long do we have to allow for a response? Would it be the same 10 days as a records request? There's no particular time, response unless your contract with the management company, gives a time that they have to respond by. I guess my feeling would be, give them enough time so they can go back and pull the records, but it shouldn't take more than 30 days for sure. And sometimes setting up a meeting might be faster than, requesting a lot of documents, having a meeting with maybe the financial person from the management company and see if you can talk through what the questions are and what you think are the discrepancies. That might be the better approach versus, having them dump a bunch of records on you. Okay, number 2, from a manager, does this new case law mean that the board cannot even vote on approval of prior closed session minutes? So yes, it does. It means no voting in executive session. So any executive session minutes from the past, that haven't been approved, you have to approve those now in the open meeting. Okay, next question, number 3. We had to condense this one a little because it was a little bit long. I am concerned that our board is using unanimous email consent to approve non-emergency items, such as homeowner repairs, and then ratifying those decisions at the next open meeting. How would this practice be viewed by regulators, courts, or other authorities? This would be viewed as a violation of the open meeting law. You should not be taking actions by written consent, whether they're unanimous or not unanimous, unless it's an emergency. Everything else needs to be done in the open meeting. And there are 2 cases by administrative law judges in Arizona that support my opinion on this. So do not use unanimous written consents as a board outside of a meeting. The only time that you would be able to approve something without giving 48 hours notice as a board is it's an emergency. And then you got to take minutes, don't forget at that meeting, and then read into the record at the next meeting what was decided at the emergency meeting and attach those minutes to that next meeting's minutes. Okay, number 4, let's see, is also condensed because it was a little long. After this new case, the Sunland Springs Village HOA case, can our HOA board still use unanimous written consent? Oops. Let's see, same question. It looks like almost identical. Can our HOA board still use unanimous written consent to make decisions outside of meetings that are open? If yes, what limits apply? And do we have to report or ratify those decisions in open meeting and include them in the minutes? So the only time you can be taking action outside of a properly noticed open board meeting is in an emergency. And like I said, you got to take minutes, and at the next meeting, you read into the record what the emergency was and attach those minutes to that meeting. Okay, next question. If we have a financial review committee and only have 3 members, can 2 members talk to each other if not in committee format? So I don't know if your financial review committee is has regularly scheduled meetings, so therefore you're subject to the open meeting law, or if your financial review committee consists of board members and 3 is a quorum. So lots of unknowns here. But if you have this question's kind of open. Can 2 members talk to each other if not in committee format? I'm not sure if they're talking about, the HOA stuff or what's going on. So I probably can't comment too much on this other than to say, if it's a regularly scheduled committee meeting and a quorum of the committee members is talking about association business, it needs to be noticed and conducted as an open board meeting. Okay, number 6, we had to condense this one too. So just a reminder, when we're teaching these classes, we have a lot of questions to get through. So you really have to make them very straight to the point, or we'll have to spend a bunch of time, trying to simplify them so that we can get through them quickly. Okay, does the new Arizona open meeting law apply to HOAs that are still under declarant control, like ours? Declarant still controls the association until at least 2027. So I'm assuming that you're talking about the new case law. And yes, I do think it applies to every association, whether they're under declarant control or not. Let's see. Most associations under declarant control, just practice pointer, are not having regularly scheduled board meetings. And I think there is a caveat in the open meeting law that says it's for like any meetings after declarant control. But if your declarant control board is having board meetings, they really should be open meetings. It would be what my recommendation would be. Obviously, this 100% applies to post-transition owner-controlled boards, but there may be, like a caveat for that. Best practices would be, in my opinion, to follow the case and to follow the open meeting law. Okay, number 7, we had to condense this one too. Our new HOA board president has started rewriting our bylaws on his own. The board has not voted to authorize this, and he has not explained why longstanding bylaws, which have been in place for 30 years, now need to be changed. He's publicly claimed the owners do not need to vote on his changes because bylaws are different from CCNRs. Can you clarify what Arizona law says about who may amend bylaws and what approvals are required? Okay, so short answer on this would be you got to check the bylaws, because the bylaws will tell you exactly how the bylaws can be amended. Question number 8, why does a receivership happen and what are the consequences? How would you address this with the community who, for the most part, seems to not care to volunteer their time? Okay, a receivership happens when a petition is submitted to Superior Court asking for a receiver to be appointed to handle the affairs of the association. So common times that a receivership would be appointed for an HOA or a condominium is if you can't find people to serve on the board, or you have no board or less than a quorum, and you can't get anybody else to serve on the board. The court, if it's petitioned, will appoint a receiver to run the association. Other times, maybe the board that's in control is not handling things well or mismanaging things, that an owner files to have a receiver appointed to oversee the board and make better decisions. So, how do we handle a community that is, doesn't care about the board or isn't interested, doesn't want to serve on the board? I really recommend that you have our firm send them a letter, outlining what can happen if we don't have a board that's serving. It's going to end up costing you a lot more money as a community because you're going to have to bring in a receiver. There's likely going to have to be a special assessment to pay for the receiver. And it's much better to try to get people to step up and serve on the board. And our firm's been very instrumental in helping associations in that situation. So reach out to us. We can show you our letter and we can strategize on what's the best way to get more people involved so you don't have to go that route with the receivership. Number 9, our HOA finance is supposed to be 100% transparent to the owners. Are there any laws in this regard? So generally speaking, yes. You are entitled as a homeowner to see all the books and records pertaining to financials for your association. A couple things you are not allowed to see, like the salary that's paid to independent contractors or to employees, the salary or the amount that you pay an independent contractor, although there's like 5 different places you can find that on the year-to-date budget and the check register. So I usually tell my boards, don't play hide the ball on that. Just tell the owners if they want to know how much somebody's being paid, let them know. Okay, next question. The only mention in our HOA documents about walls is that of party walls between houses. Who is responsible for the perimeter walls of the community, the city or the HOA? Ooh, I'm going to have to look at your plat map and also at your documents to determine who's responsible for that. I don't know if your community walls face like city property or if the association owns both sides of the walls. I don't know what your CCNRs say, so it's hard for me to answer that question. Okay, question number 11. Our community has a homeowner, Jane Doe, who has her home designated as the Jane Doe Living Trust. Our community documents specify you must be a homeowner to serve on the board or serve on one of our committees. However, the adult son has been allowed to serve on a committee and run for the board. Please explain how the son could legally be considered a homeowner. Would they need to be named as a trustee, or would the homeowner need to be incapacitated? Note, our community recently posted a vacancy on a committee and specified you only need to be a resident to serve because of this situation. So I have to find out more about the trust, the living trust, to determine whether or not the son is, able to participate as an owner in the association. And I think the best way to do that is pick up the phone and call our contact for that particular lot or unit and ask some questions, ask to see some verification documents. Would be the way that I would recommend. And yes, the person should be, like a trustee, or there needs to be special provisions that would allow him to do this. Okay, question number 12. Over the past 2 years, our association has been unable to get a quorum to conduct an annual meeting. And so therefore, there's no board elections. Thus, board positions are rolled over to the next year's annual meeting. This year, all 5 of our board members are now up for election. Governing documents indicate board members will be elected to 3-year terms. Our management firm wants to stagger the terms without modification of our bylaws. Can you comment? Well, if I had to guess, your terms probably were staggered. And because you haven't had an election in 3 years, there should have been somebody elected 2 years ago, and there should have been somebody elected last year. And then this year, there's probably some seats that are up for a 3-year term. And so I have to look at your documents to verify this, but, I do think that terms should be staggered, and the people that get the highest number of votes should get the longest term. Okay, question number 13. Is there a conflict of interest for the community handyman to be on the HOA board holding the position of treasurer? Yes, I don't like that. I don't think that's a good idea at all. And I do think that that is a conflict of interest. Now, I'm not saying that you're violating any particular Arizona law, statutory law, but this looks bad. And as legal counsel for the association, I would never be in favor of him doing this. Question number 14. I recently joined a second board as the secretary. While looking at the documents, I discovered over $2,000 of erroneous payments made over the last 5 months. Clearly, the board treasurer has not been looking at details. Do I have the authority to get to the bottom of this issue with the management company without being the treasurer? Absolutely. And it's your obligation. It's your duty of care as a board member. So I wouldn't accuse anybody of anything. I would just bring the discrepancies to the attention of the management company and the board, and have an independent party look at this to determine if there has been some sort of financial impropriety. Okay, number 15. Is a 50-unit HOA that owns no common area property and does not maintain any roads or easements subject to the community association statute? So I'd have to really see your association's documents to, formally weigh in on this. But if you're calling it a unit, so I'm kind of feeling like you're thinking that maybe this is a condominium. Although the second part of this question is kind of indicative that you think it might be a planned community. It's really hard for me to comment on this because I need to see your documents. So if common areas are owned by the association, typically you're going to be a planned community. If the common areas are owned in, percentage by the unit owners, then you're typically going to be a condominium. If you don't own any common area property, you might be a condo, but then you're talking about roads or easements. So I'm thinking maybe this is like a Northern Arizona association, but I have to see the documents to, fully weigh in on this issue. Question 16. Our CC&Rs say we can increase our assessment dues based on the July CPI. Can we increase for years when we didn't increase our dues in the past? So can we increase now up to 20% as per Arizona law? Can we make an increase more than once a year, since how often is not specified in the CC&Rs? So these are all great questions. I really do need to see your CC&Rs to give you a formal opinion. But if your documents require you to do it based upon the CPI, you follow that. You can't go back and cash in on years, maybe over the past 5 years, where you didn't take advantage of the CPI. And now you want to, link all those together and, take that big cash out now on year 5. You can't do that. I know there are some attorneys that say you can, but I'm not one of those attorneys. I'm very conservative in our advice, and I think that is going to be challenged for sure. So can we increase up to 20%? Because state law says, in the Planned Communities Act that we can do this. Well, your documents are specific about how increases are to be handled pursuant to the CPI. So no, you can't take advantage of that law. That law only applies if your documents are silent on increasing the assessments, or your documents allow you to increase above 20%. Can we make an increase more than once a year? sometimes documents do allow for like a revision to the budget, but I'd have to see your documents before I would be able to weigh in on that. Okay, question number 17. Is an HOA board legally allowed to send a bill to recoup expenses due to a board member communicating with our legal team without first obtaining permission from the board? I don't like to see that. And I don't think that they have the legal right to do that. Sometimes a board has to spend money on general counsel stuff that are the cost of doing business. And if an owner contacted the association's attorney and the attorney had to spend a little bit of money to respond or to forward it to the board, that is a board expense. And I don't think that that should be passed on to the owner. Okay, question number 18. Let's see. The board I serve on has voted by email on almost everything. When this ruling was issued, I again advised about open meeting law and copied the property manager. The board president responded, "We've always voted by email, and that's the way I want to continue." I refused to vote by email, and now the rest of the board is voting without me by email. As a board secretary, how do I proceed to protect the association given their operations? I would reach out to the attorney for the association and express your concerns because the attorney really needs to guide your board to comply with the law. I also would reach out to the management company because they should know better and they should be telling the board you shouldn't be doing this. Of course, you can always get your own independent legal counsel. You're going to have to pay that out of pocket yourself to write a letter to the board, or you could go to the ADRE and file a complaint against the board. But I would say try to work it out amicably with your board first. Number 19, are you going to go over the new law that requires all business to be done in an open meeting session now and how that will affect how we handle complaints, appeals, fines? So we did talk about this at the beginning of this seminar, how we're going to handle complaints, appeals, and fines. Usually complaints about issues are going to be handled in the homeowner forum in the open session. Appeals on fines, you can listen in the executive session, but you're going to have to vote in the open session on it. And if the owner wants it pushed to the open session under the statute, you'd have to allow for that and move it to the open session. You want to hear how this affects the association in the future and what tips there might be for planning for this change? I think don't overcomplicate it would be my thoughts. Obviously, the legislature, the reason why they're doing this is for transparency. They want everything done in the open session when there's going to be a vote. I think it's going to end up being a positive thing in the end because we're not hiding anything. As boards, we shouldn't be hiding anything. We want to be transparent. And we are only going to go into executive session when we absolutely have to discuss something that the rest of the owners shouldn't hear, like legal advice from an attorney or maybe like a performance improvement plan for an employee or an independent contractor. But I think what's going to happen now is violations and delinquencies. Those are all going to be pushed into the open session. You're going to be discussing them and voting on them now in the open session. And really, it's going to make your executive sessions a lot shorter because you're not voting on anything. You're just discussing things quickly. Okay, number 20, what is the best and preferred way for homeowners to communicate with board members? Our HOA mandates that such communication must be done by completing and submitting an online communication form. No phone calls, no texts, no emails. More often than not, there's no follow-up by board members to such submitted forms. Suggestions, please. Well, I think come to the board meetings and talk during the open forum. That's one really successful way. The board isn't required to take your phone calls outside of a meeting or exchange text messages with you or emails with you outside of a board meeting. That is, the law. They're not required to do that. So I like filling out the form that they're requiring you to do and then going to the board meeting to reiterate what you may have filled out in a form. The board should be responding to those forms. If you're taking the time to fill it out, there should be some kind of response, even if it's just acknowledgement that they received it. There should be a response from the board on that. Okay, question number 21. In open HOA meeting, can a homeowner or member propose a motion from the floor? What is the proper procedure? Is it board only? So no, members cannot propose a motion from the floor at an open board meeting unless that member is a board member. But in this case, I don't think that person is a board member. So what I would do is talk during the homeowner forum. If there's something that you want the board to hear or ask that they add it to a future agenda, I think that's the best way to handle it. The board ultimately does make the decision, though. Okay, question number 22. If our HOA management company is telling the board that they can continue to vote by email after the ruling on April 28th, what should be done? You really need to bring in your HOA attorney or your condo attorney to have a discussion with the management company about this. Like I've said many times in this presentation today, you only vote, by email in emergency circumstances where you can't wait 48 hours to make a decision on something. And this really is going to be subjecting you possibly to an open meeting law violation. And the management company needs to shape up and follow the law. Okay, question number 23. We are fairly new board, so we are still learning the ropes. We would like to use some casual meetings to work out how to respond and approach issues before going into an open session. Is that okay? Or what are we opening ourselves up to? I am an HOA board member. Okay, so you can't do these informal planning meetings. What you could do is have a boot camp with our firm where we could kind of do, it would be considered an executive session because I'm giving legal advice. We could talk through the issues that, potentially might be facing your association. We can, talk about what the law is and answer questions. That would be one way to do an executive session to talk about these topics, is to have legal counsel present, and it would fall under one of the exceptions for the executive session. If you're not doing that, you're violating the open meeting law. If a quorum of the board is discussing business, you might want to have less than a quorum discuss it. That might be a workaround for you. Okay, question number 24. I'm just going to do a quick check to see how many questions we have right now. Looks like we're up to 45. Okay, we have a homeowner that is, in her words, being harassed by her neighbor. She is fearful the neighbor is going to harm her or her pets. She would like the HOA to step in and talk to her neighbor. Our management company has encouraged her to report this to the police. Your thoughts? So I agree, definitely, that we need to put in writing to the complaining owner that they need to consider a police report, calling the police, getting an injunction prohibiting harassment. This appears to be a homeowner-to-homeowner issue that doesn't involve the association, although the association could send a letter to the alleged offending owner, just letting them know that they've received a complaint and that, we encourage the neighbors to try to work it out, maybe suggest that they contact the city to see if the city has any free mediation programs type of thing. Now, the only time it would cross over to the association needing to be involved is if there was a fair housing issue, like they're being discriminated against because, their family has children, and that's protected class under the Fair Housing Act. So I'd have to learn a little bit more about the facts maybe before I would push in and say, hey, yeah, the association has an obligation to do something. Okay, question number 25. We have a 3-member HOA board, and our property management company has advised that board members should not have discussions outside of official meetings. Good advice. Citing legal concerns. As a result, we've been told not to email each other at all, even for general discussions that don't involve decisions or voting, such as suggesting topics for future agendas. This has made us hesitant to communicate with one another, and the management company now sends emails to each board member separately. I'm concerned that this prevents us from even coordinating basic matters like planning meeting agendas. Is this level of restriction typical, and what types of communication between board members are generally allowed? So I would be okay in this circumstance to have the president email another board member one-to-one and say, here's the agenda. Do you have any suggestions? That's not going to be a violation of the open meeting law. But I agree, the president sending out a reply all email to all board members with the agenda, asking for comments, and then everybody's replying all, that is going to be a violation of open meeting law. So I do kind of applaud the management company for, being strict on this. But I think there's a workaround if less than a quorum, is talking about an issue on email. I prefer one-to-one. That's fine. Or, if you're trying to coordinate a meeting date and there's no actual official business being discussed, I think that you could do a reply all email between all the board members. Okay, question 26. How can the standards manager have an active voice with input for changes to the guidelines. It has been difficult to navigate this issue being a homeowner and working for the HOA. I don't think I've ever heard of standards manager. I'm not exactly sure who that would be. I guess maybe a manager for your association. So should they be giving you input for any guideline changes? It has been difficult to navigate this issue being a homeowner and working for the HOA. That's probably not a good idea. We don't usually hire homeowners to work for the HOA. So this question is kind of hard for me to answer because it's unclear. So sorry about that. If you want to resubmit it, we'll answer it at our first Fridays. The next first Friday is coming up in June. Okay, question number 27. What are you supposed to do when you request a copy of a payment for a large, what should be capital expense is not documented or identified on the financial report that I can see, but there was a large sum removed from the reserve as an expense with no detail, but shown as a loan and a liability. I've sent a certified letter with my concerns and request a copy of this payment to the vendor, and I'm being ignored. Well, you're entitled to see a copy of that payment. You're entitled to see a copy of the bank statement. And there also should be minutes that reflect this decision as well. You'd be entitled to see all of those. So I don't know if they're trying to hide something from you, but you may want to get an attorney. You may want to document your concerns in writing, especially if they won't give you the documents. And you may want to consider going to the ADRE to see if that might be a venue where an administrative law judge might, rule in your favor and make them provide that information to you. Okay, question number 28. The statute requires an audit, compilation, or review every year. I found standards for compilations and audits, but have not been able to find a standard for a review. Who should conduct it, and what is the standard, if any? The law doesn't give us any information or suggestions on who can conduct it or what the standard is. So you could go by what generally accepted accounting principles or procedures, which probably a definition of it there. But my experience with boards is that they, don't really have a standard for a review, and they don't really have a standard actually for an audit or a compilation unless it's been conducted by a CPA, which kind of leads to the point that, hey, this law is pretty loosey-goosey and there's a lot of holes in it. Like the intent was to make sure that associations are really looking at their financials, having a third party look at it with an audit review or compilation every year. But the reality is, unless your documents require it to be done by a CPA, it doesn't have to be done by a CPA. And most boards don't have the money to even hire a CPA to do an audit like this. So it's kind of like a, Swiss cheese law where there's a lot of holes in it. Okay, question number 29. Our documents state that we will have meetings every other month. There has only been one executive meeting since last November. The office does not reply to the question when the next meeting will be, but several board members are on the committee and it continues to meet monthly closed. What recourse do homeowners have with the lack of transparency? This is not good. So I would write a letter outlining your concerns. You certainly, to the board, you certainly have the right to go to the ADRE. You have the right to hire a lawyer to send a letter. You can send a letter yourself outlining your concerns. You can run for the board. You can think about moving. You can remove these directors from office under the removal law that we talked about. So there are a number of different things that you can do here. Question 30, can you share about the requirements for a movie night? Yeah, I'm planning it. So I'm on the Family Activities Committee for my association. So I did a little bit of research on this yesterday, and I've done it previously in the past a couple of years ago, and we kind of decided not to do it because it was too expensive. But here are the requirements. You should Google whatever city you live in and, company that, brings in a large movie screen and has the copyrighted and trademarked movie rights. And there's 3 companies, I think, that do it in Arizona. And basically you go to their website and you kind of look at what the different requirements are. So they only have the rights for certain movies, and you have to pay for the screen. You have to pay the trademark or copyright fees as well. And you can't just rent a screen and not ever pay those fees for the copyright or trademarks, because the movie companies that produce these movies take this very seriously, and if it gets back to them, they will sue you. over this. So there are companies that are out there. If you want to call my office, I can maybe help you walk you through it a little bit more, but that's generally speaking what you need to do. Okay, question 31. If the open meeting law says all members can attend, what about members who owe the association money? So they're not in good standing. Can they attend? So yes, they can attend still. That doesn't take their right away to attend a meeting. Okay, question 32. When a community is meeting with a vendor regarding a community project, does this have to be an open meeting? Based upon what I believe, I heard the answer is yes. So I would say yes. The only exception would be is if we're going into an executive session topic for this, which would be like compensation of this vendor or job performance of, or complaints that could be pushed to the executive session. Question 33 from a manager. I have a candidate running for the board who collected ballots. It's not a secret ballot for this election from about 40 homeowners and then dropped them off at our office. The ballot says homeowners can drop off their ballots, but doesn't specify that anyone else can't do it for them. This is the candidate's argument. The current board is not okay with this as they feel there's a chain of custody issue. I value your opinion so much. What are your thoughts? Well, if the ballot wasn't clear and it didn't say that the homeowner has to drop off their own ballot, it's probably legal if this person who is a homeowner dropped off a number of ballots, including his and then a number of neighbors that he solicited the ballots for. So it's probably okay. Okay, question 34. Our property manager will not provide the board's request for proof that our maintenance company is vetted. Well, that's not a good thing. You want to make sure that whoever your maintenance company is licensed, bonded, and insured. I don't know what else you need to have vetted, but if it's in the contract that the management company is supposed to do this, they should do it. If it's not in the contract, then maybe you might need to do it as the board. Okay, question number 35. Our president authorized HOA funds to repair her unit. There was $1,500 paid and damage was not the HOA's responsibility. She refuses to pay it back. Can we take her to small claims court? Is this the only option? So, yes, you can pursue litigation against this particular former president. I'm assuming it's former. Hopefully it's former. Try to work it out informally if you can. And if you can't, then of course you have the legal right to go to court. And you can represent yourself in small claims court as the association. There is an exception in small claims court that you can do that. In justice court, you would have to get an attorney if there's more than the statutory limit in dispute. And it gets pushed up to justice court. You have to have an attorney to represent the association. Okay, question number 36. Since voting is no longer allowed during executive session, if a homeowner requests a hearing, for example, they have not paid assessments for the past year, then that hearing is conducted in executive session. We have quarterly meetings, so the board would need to discuss the request 3 months later and vote on this in an open board meeting. So I would say yes, under that new case, that is accurate. It needs to be done in the open board meeting, the voting. You could discuss it in executive session, but the voting is in the open session. That means the owner would not get a response for 3 months. Well, yes, just have an open meeting after the executive session where you vote on it if you don't want to wait 3 months. And their personal situation will be discussed in an open meeting. So that's a good question. So you could just use the lot number instead of using their names. And put when you vote on it in the open session. Okay, question number 37. Let's do a quick check to see how many more questions have been added. So we're 46 questions, so we're getting down to the end. Okay, our bylaws require that a compilation, audit, or review be prepared by a certified accountant. Does this bylaw provision override the requirements of Arizona Revised Statutes? Or do our documents, control here? There's a conflict. So there really is not a conflict. Actually, you read these two together. So if state law says you have to have an audit, review, or compilation annually, and it says that if your bylaws require that to be done by a CPA, it has to be done by a CPA. So these mesh really well together, and you're going to have to do that every year and use a CPA. I haven't seen the exact language of that, but, I don't know if the CPA can do either audit, review, or compilation, or how it's worded, but you want to look at that wording carefully. Okay, question number 38. What options does the board have when a director routinely fails to participate in board business and meetings, makes inappropriate comments about homeowners, and disrupts or derails meetings, creating a major problem and potential liability for the association? So you've got a bad board member. Obviously, this doesn't sound like a good situation. You may want to get your legal counsel involved to help advise you on this. Maybe I come for a boot camp. Maybe, your attorney has a meeting with the board where we clear the air on these issues. Maybe a violation letter is sent to the board member who is not behaving properly at a board meeting, and have that sent by the association's attorney. There are options. I would start first with communicating, see if we can get anywhere with that. Obviously, you have the option of removing them. Got to see how long their term is. Can we wait it out for the term to be over? All of these are really good suggestions on how to best manage this difficult situation with your difficult board member. Question 39. If a former board member influenced a past election by telling homeowners not to vote for a particular candidate, and I have verbal confirmation from multiple residents, is there anything a current board can or should do now? Really not too much you can do on this. Is it appropriate to put safeguards in place for future elections? I think having a candidate form where candidates can cite their name, their professional experience, and why they want to be on the board is a really good tool so that people can make an informed decision about who they want to serve on the board. And, if other owners want to go out there and say things, we can't really stop that from happening. Number 40, do you have to post executive session meeting minutes on the website or let owners request them? So short answer would be no. This new case does not give owners the authority to see executive session meeting minutes. But remember, all they're going to say is that you discussed a topic. There won't be any voting there. Question number 41, how long must records be kept for the HOA? What happens when they tell you they lost them? Okay, we have a great cheat sheet on records retention. So generally speaking, records should be kept for somewhere between 6 and 7 years because the statute of limitations to sue for breach of contract is 6 years. Some things are kept forever. You want to look at our cheat sheet on that topic, like the CCNRs or the bylaws, the rules, that type of thing, the minutes of the association, those should all be kept forever. But look at our cheat sheet for more specific guidelines and a detailed deep dive on that. What happens when they tell you they lost them? Well, not much you can do. If they've lost the records, they no longer exist. Question 42, we are a new board and we also just moved management companies. Unfortunately, the oversight of the transition from management companies was not done properly with the old board. So the new board had to work through everything with the new management company. This requires a lot of phone calls, text messages, etc. Is this executive session, or are we just working to get our HOA management company and our new board on the same page to ensure that the management company is providing all the necessary operations? I want to abide by all necessary laws. So what I would say is just have less than a quorum working with the new management company to get this set up, and we'll be fine. Question, or notice it as an open board meeting anytime you're discussing this with them, and have a quorum of the board present there to discuss it with the management company. Okay, next question. We are down to our last 5 questions. So this question is, if we decide to offer Zoom coverage for our monthly board meetings, are we required to allow member comments or questions from remote viewers? So yes, before the board takes formal action on something, you would be required to at least allow them to say something in the chat. Next question, can the president of a sub-association be the president of a master? So unless the documents prohibit that, I would say, it's okay, but it's unusual because being president of just one association is hard work, but being president of 2 is a lot of work. And I'm not sure one person can do that. So, and also I think there could be potential conflict of interest issues. So I'm not encouraging this either. Okay, next question. Regarding the law that says HOAs must allow owners to put in solar, does that apply to condominium communities also? So I did mention when I was doing the presentation here today that condominiums have a little bit different analysis because it depends where the owner wants to put it. If it's on the common areas of the association, they really can't do that without board approval, and most boards aren't going to approve to put a big solar energy device, on the common area, by the pool or on a roof, because it's going to void the warranty. So short answer would be, yes, I think it's 33,349 does apply to both planned communities and the condominiums, but we don't really see this in the condominium context very often because they can only put it on their property. And there wouldn't be any their property that's solely theirs in a condominium. Okay, question number 46. Does a board make the motion and second and then discuss the issue in executive and then only take the actual vote in the open? So that's a good question. All you do is discuss in the executive session. The motion and the second should be done in the open session. Okay, last question of today. If our community needs a new road, but we can't get the 3/4 votes to complete the project and get funds from the owners, what recourse does the board have? I think you need to strategize with your attorney about, where you are, what our next steps would be. You might want to consider getting a loan. You might want to consider repackaging this as a special assessment, maybe add some time to it, get some advice. Like, our firm's really good at strategy on this stuff. You can't get the 75% vote. So let's go back to the drawing board and come up with a strategy to get the money that we need. Maybe we partially fund it with a loan, or maybe we, use some of the reserve money. Maybe we do a special assessment that's lower. Maybe we give people a payment plan on special assessment. But, there are lots of options to pivot here, but I need to look at the documents and kind of go over how you structure the first vote to better understand. Okay, wow. We had a lot of people here today, 191 viewers. This is like a record for 2026, which is amazing. So thank you so much for having all of you here today. I guess at one point we had actually 200 viewers on this class today. So that's amazing. Thank you very much for coming to these classes and wanting to improve your association. We appreciate it. Okay, let's talk about a couple other opportunities in May and in June for you to get on a virtual class and learn more about our HOA and condo laws. So we have a surprise HOA summit on Wednesday, May 20th, 2026. It's going to be from 6 o'clock p.m. to 8 p.m. It's going to be on Microsoft Teams. I'm sorry, I don't know the exact name of that. Maybe my office can check that real quick and add it to the agenda. What the topic is for the surprise HOA summit on Wednesday. I looked at it this morning, but there's been a lot going on this morning, so I forgot already. Or you can check our website, which will have information on that as well, in terms of what the class topic is going to be. And that's going to be, tomorrow already. So my team is so fast. I ask, they answer. So a practical and effective guide to HOA and condo enforcement. So we're going to talk about how to enforce the documents if you've got owners who are violating things in your community. That's going to be from 6 to 8 p.m. on Wednesday, May 20th on Microsoft Teams. And if you want more information on how to join that, just go to our website at mulcahylawfirm.com. We also have our First Fridays coming up on Friday, June 5th. From 9 a.m. to 10 a.m. where we hop on Zoom and Facebook Live and answer questions live. So if you want to submit a question, go to our website, mulcahylawfirm.com, to submit a question. And then last but not least, in June, we have another Neighborhood Services Virtual HOA Academy on Tuesday, June 16th at 11 a.m. And we're going to be talking about how to thrive as a board, how to define what your roles are, how to avoid burnout, and how to hire right, meaning the right management company, the right vendors, etc. So that's going to be a really interesting class. Looking forward to teaching it. So thanks everybody for being here today. Appreciate it. Sorry we went a little long. It's about an hour and 15 minutes of class time, but a lot of great information here today that you can use to make your communities better. So thanks again for being here today. Take care and have a great rest of the week. And happy Memorial Day. Take care.